All right. Well, welcome to this presentation for the Purdue Global Law Society. My name is Brian Craig, and I'm joined here today with Christina Nolan, and we're going to be talking about selecting primary and secondary sources and writing a case brief. And I think these are really helpful tools that will be applicable for anyone, uh, and we'll try to share some information here. And if you have any questions uh, or comments as we go along, feel free to use your microphone and your video and the chat box, any of those. So it's not doesn't have to be just a full-on lecture for 60 minutes. We can certainly make this a little bit more interactive for those who want to participate. So all right, well let's jump right in. Yeah, I'll just introduce myself. My name is Brian Craig, and full-time faculty member here at Purdue University Global. I teach a variety of different courses. Um, and and then Christina, if you want to just briefly introduce yourself. I think Christina went on mute, but yeah, Christina Nolan is be kind of doing the second half, and she's also going to be she's also a full-time faculty member here in School of Legal Studies. So, well, let's jump right in. Let's talk about different types of primary sources and secondary sources. So, when we talk about primary sources and secondary sources, kind of like two main categories under legal sources. And just give you a little bit of background. My background, I've been a lawyer for about 24 years, and I actually used to work in a print law library, and I actually find that really helpful. I actually, when I was an undergrad student, I worked at it was a government documents collection, and then we would get a lot of different materials, and I worked for another law library, and I found that really helpful. I haven't set foot in a print law library for more than 10 years, but having that foundation, I think, is helpful. Now, a lot we can do online legal research. So we have these two main categories of legal sources when we're doing legal research. We have primary sources and secondary sources. And the primary sources is the law itself. And then we have secondary sources that help us find primary sources and also help explain those primary sources. So primary sources include constitutions, so the U.S. Constitution as well as state constitutions. Um, and then we also have statutes. Those are laws passed by the state legislature. Some states we might also have like legislative initiatives or referendum for statutes. And then we also have regulations, which are laws passed by administrative agencies, and we have some administrative decisions. And then obviously we have case law. Those are judicial opinions from courts, like U.S. Supreme Court cases, or if you're in California, a California Supreme Court case, or maybe a case from a different circuit. And with that. So those are our primary sources. We also have even city ordinances and county ordinances would also kind of fall under legislative enactments similar to statutes. So when we're talking about primary sources, that's where those main the law itself. Other miscellaneous primary sources would also be like executive orders by the president or the governor, uh, international treaties. Those would also be considered primary sources. Then we have secondary sources, books and treatises, like a legal treatise on a particular topic, or what's called a horn book, like Prosser on tort or Williston on contracts. Dictionaries, English language dictionaries, as well as law dictionaries, such as Black's Law Dictionary, which is cited frequently by courts. ALRs, I really like ALRs. If you can find an ALR that's on point relating to your topic, a lot of your work is already done for you. And then you can break that down by jurisdiction and so forth. We also have legal encyclopedias. So we have like American Jurisprudence, which is a national legal encyclopedia. And then in some states, like California has California Jurisprudence. New York has some of your larger states have state specific materials, and then practice guides. Like when I was in Minnesota, there's Minnesota Practice Series, which is actually a really good secondary source. And then we also have periodicals. That would be things like law review articles, bar journal articles, like an article from Harvard Law Review or something like that. So those would all be considered secondary sources. And the nice thing about law review articles is they have very extensive footnotes. And then if you're looking at like Westlaw or Nexus online legal research platform, then a lot of those footnotes, you can just click on those links within those documents, a law review article, and it'll take you immediately to that case or statute or whatever is being cited. So those are our two main categories under legal sources. Any questions on the distinction there between primary sources and secondary sources? So another way of looking at primary sources are books and uh, online websites that compromise the formal written statements of law issued by governmental entities. So we kind of think as the law itself, right? And how we go about finding those is we do several different sources. Sometimes we'll search directly in the statutes. I actually find searching case law to find statutes is a good workaround as well. Sometimes, or using index or keyword search, or just browsing the table of contents and statutes can be helpful. So a lot of things that we do nowadays are back in the old days would be print, and now a lot we can do is in electronic format. So, and then we also have primary sources that are broken down between federal and state. And then even within state, we also have city ordinances and county ordinances. And federal materials, we have the US Constitution, and then federal administrative agency regulations, like maybe regulations from the FCC, Federal Communications Commission, or US Department of Transportation. And then we also have administrative decisions, like maybe it's a decision from the Trademark Trial and Appeal Board, which can have a very important impact. We also have statutes, the United States Code, those compilation of all federal statutes that have been codified into 50 different titles or different subjects, like Title 28. Some of you are probably dealing with the judiciary, or the Internal Revenue Code, Title 26, right? We're starting to get like W-2s and tax statements this time of year, right? That's all under Title 26 under the U.S. Code, which is the Internal Revenue Code. And then we have federal cases, U.S. Supreme Court cases from different circuits, and even U.S. District Court cases and other miscellaneous courts. Then we also have at the state level, state constitutions, and sometimes state constitutions, they're kind of called it's the U.S. Constitution is considered a floor, not a ceiling, right? So some state constitutions can provide for even greater rights than some U.S. constitutional provisions. For example, the right to education the word education is not expressly found anywhere in the U.S. Constitution, but a lot of state constitutions do provide for a right to education, or right to privacy, for example. I think 9 or 10 different states have an express right to privacy. State administrative regulations, so we have different state agencies over different things. And then we have state statutes. And those names can sometimes be varied. It depends on the state, those state statutes. I live in Utah, where it's the Utah Code, which are the statutes. But then we also have the Utah Administrative Code, which are regulations. The name varies from state to state, so just be familiar with it. So statutes are passed by the legislature, regulations are passed by administrative agencies. And then we have state case law as well. So if you're in, like I said, in California, then would be California Supreme Court, or if you're in Illinois Supreme Court. So secondary sources help us understand the law, and can also help us find those primary sources. Sometimes finding primary sources, it's easier to run a search in case law or law review articles to find applicable statutes. So let's just break down the U.S. Constitution. So we have the preamble that starts with "We the people of the United States in order to form a perfect union." And then we have the 7 original articles to the Constitution. And then we have the 27 amendments. Those are the express amendments to the Constitution. So, all right, we'll play a little trivia time here. So, which article of the Constitution covers the power of the president? You can answer in the chat box here if you know that one offhand. If you don't, that's okay. So which article in the U.S. Constitution covers powers of the president in the executive branch? Right, excellent. Article 2, and I like using the Roman numeral. Way to go on that one too. So yeah, Article 2. So Article 1 is the power of Congress. Article 2, the executive branch or the president. Article 3 is the power of the courts. And we have the other articles as well. Perfect. Okay. So how do we find the Constitution? Well, we can find a lot of different places, right? The Constitution itself, you can go to congress.gov. We can find it through the National Archives if you want to see the actual images. I actually had an opportunity to present at a conference a while back in Washington, D.C. And I spent a little bit of time going to the National Smithsonian, and there's the National Archives building. And that was really an amazing experience. I hadn't gone since I was a child, and been like more than 40 years since I went to the National Archives and saw the original Constitution and then the Declaration of Independence and other under founding documents and the Bill of Rights. So if you're ever in Washington, D.C., I encourage you to go to the National Archives. Make a reservation first, though. And then we also have state statutes, and we can find those in a variety of different locations. And, I mean, and you want to make sure you go to the official. And one thing is if you search for some states, kind of just a quick way of doing that. Let's say you're just doing a Google search, and you could add like a site .gov, right? And if you run a search like that, then it limits your search, and it limits like .com websites. So let's say if I just do a Google search or whatever, and a lot of places, you have it bookmarked. I really find using Westlaw helpful. Like I said, I used to work for Westlaw. I was a reference attorney for a number of years, and that's my go-to place, right? I would say 98% of my legal research I do on Westlaw. And so if you go to the table of contents, you can do the index search, keyword index. You can do a search. And the difference between annotations and unannotated version is the annotations includes a lot more information. And it includes things like summaries of cases, legislative history, and other research tools. Great question from Jess in the chat box. What's the difference between Westlaw and LexisNexis? Yeah, so they are both online paid legal research platforms. They're both two different companies, and they compete against each other. And a lot of the content is very similar. It's kind of like the difference between Ford and Chevy, or Toyota and Honda, right? I mean, they can get you to the same destination. It's just a different way of getting there, right? And the user interface is a little bit different, and some of their search algorithms are a little bit different. Sometimes some secondary sources are exclusively on Westlaw, and some are exclusively on LexisNexis. So you'll see that, for example, like Matthew Bender forms, you're not going to be able to get those on Westlaw. And Westlaw, it has exclusive content that you're not going to be able to find under LexisNexis under secondary sources. So some law firms, large law firms, they might have like Westlaw as their primary, and they maybe have Lexis as a backup so they can access to some of those secondary sources. As far as primary sources, you should be able to get all your primary sources of either Westlaw or Lexis. If you're working in the legal field, most firms will have one or the other. If they don't, there are some other ones. I'll be honest, none of them really have a very good site checking software feature similar to Westlaw and Lexis. And my personal opinion is if you're not using Westlaw or Lexis, and you're doing active litigation, you're opening yourself up to potential issues. So. Black's Law Dictionary is available. It's on Westlaw, so it's under secondary sources under that. So, Black's Law Dictionary has a lot of really helpful information, and it's cited frequently by courts. So, if you have a choice, again, instead of the original text of the Constitution on like the Congress.gov website, maybe going to Westlaw and doing that. Also, just running a search in case law. That's a really good workaround for constitutional provisions. Run a search in U.S. Supreme Court cases, and they're going to cite constitutional provisions, specific clauses and things like that. That's a good workaround that I'll do too. So, statutes. Now, the term code is kind of an ambiguous term. Code can refer to statutes or regulations. So when we talk about statutes, these are laws passed by the state legislature. And again, the name varies from state to state under your state statutes. Statutes, I like using the table of contents, and I like using the index, the alphabetical index. I actually used to work for another company called Walters Kluwer or CCH a long time ago. And I was actually an indexer. So one of the things that I did is I would look at new statutes that were passed, new legislation laws, and then we would go through and we would do keyword indexing, right? And so we would index those and assign certain terms, right? And then Westlaw and Lexis, they have very similar features. So I like using the keyword index. So let's say if I want to look under the index, under my state statutes for a particular term, I just look under the alphabetical index. You click on that link, and then it'll take you to the corresponding statutes and do it that way. You can also run a keyword search, a natural language search. You can also search by certain fields on Westlaw or Lexis. One field I like searching for on Westlaw for statutes is the preliminary and caption field, right? So let's say if I want to search for certain key terms, then I can search in the preliminary caption field. So PR, comma, CA, that's preliminary and caption. So instead of anywhere within the text of the document, I can search just in the preliminary caption field with whatever key phrase I'm looking for. Whether, let's say I'm looking for like a venue statute. Finding the venue statute under Title 28, there are lots of different statutes you'll find that have the word venue. But if I search just for caption field for venue, right, in Title 28, then what happens is it limits my search just to a specific title and then in the caption for venue, and then that'll pull up the venue statute pretty quickly for me. So searching fields is a really nice way when I like searching on Westlaw for statutes. So kind of give you a little bit of background about legislative process, and if you've ever seen the old Schoolhouse Rocks, I'm only a bill sitting on Capitol Hill. Actually, I have a 11-year-old daughter, and I reviewed that just recently with her. We just found it on YouTube, and she had never heard of it, and I showed it to her, and she's like, "This is kind of corny," but it is, but it's actually really good too. So if you've never seen it, I encourage you to watch that. It's a little short little video and song. But anyway, the legislative process is we have bills that are introduced in Congress and the state legislature, either in the House or the Senate. If it's a spending bill, it has to be first introduced in the House. Then it goes to committee, then it goes to the full floor chamber if it gets passed through committee. Sometimes it might go through multiple committees. Then it gets sent to the other chamber. The other chamber can either amend it. So, like, for example, one of the big bills that was passed just this current congressional session is the Big Beautiful Bill Act, which was H.R. 1, right? Which deals with a lot of different topics. And so the Big Beautiful Bill Act was passed by Congress. So it went to the House and the Senate, and then they voted on it. And then the same version has to get passed by both the House and the Senate. And it has to be the exact same version. Sometimes they'll go to conference committee where if the House and the Senate, they can't agree. Sometimes they'll have a House version and a Senate version, and they'll kind of work through their differences. And sometimes it just dies, and getting things through Congress can be pretty challenging, especially in our current political environment. The Senate, one of the big challenges is for non-spending bills is we have to get past the 60 vote threshold, which is for the filibuster. So can't even the Senate for major pieces of legislation, like for example, appealing the Affordable Care Act. The Affordable Care Act, when it was originally passed, had a 60 votes to get that passed. But now to repeal it, it's going to require 60 votes. So, in our current political environment, it's probably unlikely to be able to get major changes without having compromise. So yeah, we'll see what happens, with the new government shutdown. And I try to be very objective, and I'm not super partisan. I actually worked in the California state legislature for a year, and that was a very helpful process. So, yeah. So the comment from Ann in the chat box. So both paper. Well, before it goes to the president, the bill version has to be passed by both the House and the Senate in the exact same language. So we can't have two different bill versions that go to the president, what's called enrolled to the president. So, but yeah, any bill that is passed by Congress has to go through the House and the Senate, and the House and the Senate has to be the same language. And if there is a dispute between, maybe there's a House version or Senate version, then it'll go to conference committee usually. And sometimes if they can't get it through conference committee, then it just dies. And we've seen that sometimes a bill gets passed by one house, one chamber, and doesn't get passed by the other chamber. So, and we'll see that sometimes. So where do we find statutes? Again, we can find them on Westlaw or Lexis if you have access to that. working in practice. As a student, you have access through Purdue University Global Library for Westlaw through Westlaw Campus Research. Also, Hein Online, a lot of state websites, they make them available. Federal statutes, we can also find them online. Uh, the, uh, the US Code.house.gov or Senate.gov. When I actually used to work on Westlaw, they would actually, when they would get their content, would actually pull them from the government websites and then update them that way. So, and add those additional editorial enhancements. So whichever particular state you're in, be familiar. You might just bookmark your state statutes and then do it that way. I really like using Westlaw. I'm a little biased. Like I said, I used to work for Westlaw. It is really a very powerful search function. And the nice thing on that is I've even seen on state statutes websites is maybe you're looking at the state statute, but maybe that statute's been held unconstitutional. It's not going to show up on just the official government website. For example, I live in Utah, and there's a statute for grandparent visitation, and it's a statute for grandparent visitation, and it doesn't show anywhere that statute has been held unconstitutional. But if you pull a search on Westlaw, there's a big red flag for that statute, for that state statute dealing with grandparent visitation that was held unconstitutional by the Utah Supreme Court. So, I always will use Westlaw because it'll tell you and give you additional information, or if that statute's been amended or repealed and things like that. So that's one thing that's really helpful. A comment from Christina. Westlaw did a great job marketing, more user friendly. Yeah, and maybe it's just a matter of what you're more familiar with. I've used both. I've used Westlaw and LexisNexis. And one thing that I really like about Westlaw is the key number system, and they have the Westlaw key number system is exclusive to Westlaw, which you don't get on LexisNexis. LexisNexis has its own version, but one of the big advantages I like of Westlaw is that key number system, because if you can find a key number on point in case law, that's very helpful. But LexisNexis, usually it's less expensive, but it's not as robust, let's put it that way. But both of them are working very hard in developing AI tools and with that too. So here's just a screenshot of the state for Indiana for state statutes from the official website there, so you can see. And again, I personally wouldn't rely exclusively on just the state website for statutes, because that statute might have been held unconstitutional. It might have been reversed, might have been repealed. Maybe there's pending legislation that you want to know about. So it just gives you more information if you pull it off Westlaw like this. All right, any questions about statutes before we jump in here and talk about cases? Okay. So I'll do about 7 more minutes, and I'll turn the time over to Christina on doing case briefs. So cases are opinions written by courts. Usually it's an appellate court, sometimes at the trial court level, district court level, but that carries less weight and authority. So an example might be the Loving Virginia case. That was a U.S. Supreme Court case that deals with the fundamental right to marriage that prohibited the Virginia state statute that prohibited interracial marriage. If you've ever seen, there's actually a movie that was made on that called Loving. So if you're interested, it's a pretty decent film. So I give like movie references. If I have any students with that, so they'll know about me because I like giving movie references in my seminars. So we have case law at the federal level and at the state court level. So here's kind of just a breakdown on the left-hand side of the federal court system. So we have the U.S. Supreme Court, so the highest court, and then we have the U.S. Court of Appeals for different circuits. There's the U.S. Court of Appeals for the federal circuit. They have exclusive appeals over patent infringement cases, also appeals from the Trademark Trial Appeal Board. We also have the U.S. Court of Appeals for Armed Forces, and then we also have at the trial court level the U.S. district courts, and we have specialized courts as well, like the U.S. Tax Court or the Court of International Trade, U.S. Claims Court, things like that. And then at the state court level, just be familiar with the state usually you're going to have, most states have a three-tiered system similar to the federal court system. We have the trial court, it's called the district court, superior court, circuit court, just the name varies. And then we have the intermediate appellate court, and then the highest court in the state. Most states it's called the state Supreme Court, although some states like New York, it's the New York Court of Appeals, which is the highest court in the state. Or if you have a state like Texas that has Texas Court of Criminal Appeals, which is highest on criminal cases, and the Texas Supreme Court highest on civil cases. So just be familiar with the state court structure in your specific state. Any questions on that? Oh, back to the slide here. We can find cases, like I said, through Westlaw. That you can also find them on like Justia or the U.S. Court's website. But again, those are not going to tell you if the case has been reversed or overruled. So if you use a site like Westlaw or Lexis, then it's going to give you a lot more information. Question, only trial courts involve juries? Right. So the trial court level, that's where we have like the U.S. district courts at the federal court level, that's where we have juries. And then if somebody was appealing that decision, we go to the U.S. Court of Appeals for the different circuit. And if maybe there was an appeal other on improper jury instructions or something like that. So only rarely will we have U.S. Supreme Court cases that have what's called courts of original jurisdiction if it's a case between two different states. So let's say Arizona is suing California over water rights, over like Colorado River water, then that goes to the U.S. Supreme Court. It doesn't go to the trial court, the district court, and the U.S. Supreme Court will assign a special master, and the Supreme Court, they kind of just adopt whatever the special master does. They are that's what happens in those cases. But usually it's not a jury in those cases. It's a non-jury decision. That's a great question. So, but yeah, juries would be at the trial court level. All right, and then we also have administrative rules and regulations. At the federal level, these are found in the CFR, or Code of Federal Regulations. So it's compilation of all the different federal regulations. It's a huge publication. It gets updated. And researching it, again, you can search on the official publication version on the ECFR website. You can also find it available through Westlaw or Lexis. The version of Westlaw does include notes of decisions and additional references. So, rules and regulations, again, we can also find these at the state level for your particular state, and the name varies from state to state. All right, so that's kind of just an overview of our primary sources and secondary sources. Any questions about the difference between those two? Hopefully, just again, I mean, if you take a legal research class, we cover it in a lot more detail, but this is kind of just a brief overview related to those. Excellent. So, all right, well, I'll turn the time over to Christina, and she'll tell us a little bit more. I'm going to skip over secondary sources just in the interest of time under that. And then she'll talk about briefing a case. And if we have any time, then we might circle back and talk about secondary sources. So, okay. All right, Christina, you can go ahead whenever you're ready.
Hi, everyone. I'm Christina. Thank you so much, Brian. That was a great presentation, and I liked your little anecdotes of and also some great questions from the audience. Thank you all for coming. And then also, in case I forget at the end, I do want to remind you that this is being recorded and will be available on the Legal Studies YouTube channel, so you could watch this again and again. So I will be discussing briefing a case, which is one of the first things that you have to do. Well, you're already doing it at the college level, which is amazing. When I went to law school, I was an English major. So I actually read a couple books about law school before going to law school that introduced me to briefing a case. But that is one of the kind of standard ways that you learn the law in law school. But you are, for anyone here that is planning on going to law school, you're being exposed to this very early, so you're going to have a major advantage over others. And if you're not going to law school, obviously, being able to brief a case is a really important skill to bring with you to the law office. Oh, nice, Carrie. Awesome. Future prosecutor. It's a great skill to have as a paralegal, and you may be asked to do it by a supervising attorney, or you may be asked to write something up that necessitates you using case law, and then you will want to brief the case. And this is especially helpful with a longer case. And I'm gonna mention at the very end. I'm gonna mention a little bit of something on AI with regards to briefing a case, but we'll get to that at the end. First, we're gonna learn about how to do it, the manual way, the way that you should learn how to do it. Okay, so next slide, please, Brian. And so what is a case? I know all of you are probably very familiar with cases at this point, or maybe some of you are newer, and you've had limited exposure. Essentially, appellate courts issue opinions that interpret and apply the law. So the opinion, the sort of decision of the appellate court, is what we refer to as cases. So you've probably also heard the term FIRAC, or well, yeah, I guess we say it as FIRAC. FIRAC is an acronym. And basically, it's a short summary of the court opinion. You've got the facts, issue, rule, analysis, and conclusion. I'm trying to think. I've occasionally seen. I'm trying to think what it is now. Sometimes it varies. Um, you know, Sometimes it'll be like sometimes there'll be different versions of FIRAC, with slightly, yes, thank you, Katrina. Yes, applicate, thank you. But they're generally kind of the same thing, um, you know, with slight differences, but ultimately the purpose is the same. Think about it. Let's say, you're researching. Oh, awesome. Thank you, Brian. Let's say you've got some complex legal issue and you've got tons and tons of cases to read through. And maybe half of them are important to, whatever you're writing, whatever the research, whatever issue you're researching. You want to be able to go back to that case brief and sort of like get the gist of that case without reading the whole case again. So you essentially read the case, and we'll go through the process, but you're reading the case, you're doing the brief, and then you have that brief permanently that you can, maybe 2 weeks later, wait, what was that, Smith v. Jones case about again? You go to your brief, and if you've done a good job, that brief will give you enough where you don't have to constantly go back to that, 20-page case, read it all over again to refresh your memory. You've got this case brief. And they're used in research and writing as organizational tools. Let's also say your supervising attorney, maybe you mention a case to them and they don't have time to read the whole case. Can I see your case brief? And then they may quickly go to looking at the issue and the rule. They may go to a specific section. Maybe they skip the facts and they look at the issue. Oh, is this case is this related to our issue? Will this be helpful? And they may be able to look at your summary, your case brief, and look at the issue and say, oh, no, we don't even want to use this one. This is unrelated. So again, this is a real time-saving device. And it takes a little bit to complete the case brief, a little bit of time and effort, but it usually pays off. They are also used to help us better on, oh, thank you, Brian. Case briefs can also be used for summary judgment motions. Great practical application of the case brief. They also help us better understand what happened in those cases or the court's opinion. Now, what I like too is you can read the case, and you know how sometimes you zone out while you're reading. The case brief forces you to really say, okay, wait, what is this case about? Let me figure out what is the issue here, what are the relevant facts, and it forces your brain to pick out what's necessary and what you need to know about that case, and then keep it in this permanent form, the case brief. So you have to be awake while you're reading the case. And again, like there are some, as you pointed out in the comments, which is awesome, in the chat, that there are different formats, but essentially they are standard. There is a standard format, but it can vary by attorney. Maybe one attorney learned it a certain way in law school. That's the way they want you to do it. But generally speaking, if you understand the FIRAC format, you'll be able to adapt it. Next slide, please. So some cases are going to be short and to the point. You can read them very quickly. You understand, maybe don't need to brief that case. Or maybe you do just for organization purpose. Maybe you want to have a case brief just so you can look back at it later. Of course, other cases are much lengthier. Also, as we, if anyone's had any experience reading opinions yet, you'll know that many are not always easy to understand on the first round. So, depends on the judge, or depends on their, the law clerk who's helping them write it. Are they a good writer? Are they really into legalese? So you may have to read a case a few times before you're able to I think this might be one that we have a little ghost in the PowerPoint. You may need to actually read the case a few times before you're able to. Oh, yes, Jess. If the case is historical and uses language 100 years out of date, exactly. You've got to. It's almost like a different language. So you may have to read it a few times. And again, don't panic if you don't understand it that first time. No problem. Just read it a few times. You are probably not alone in having to do that. But again, as you get more and more practice, and again through your college years, in your legal studies degree, and then even on the law school, as you read, the more and more court opinions that you read, you're going to start recognizing things very quickly. It's going to get a lot easier to understand the case and then do the brief. Next slide, please. So we mentioned this case, Loving versus Virginia. It's a United States Supreme Court case. As Brian mentioned, there is a movie about it, which I've heard is awesome. I have not seen it. It is on my list. It's a 1967 case. And it was an interesting fact. It was decided by the now infamous Warren Court, headed by Chief Justice Earl Warren. Honestly, whenever you think about this case, it seems like this is from the distant past, but 1967 was not that long ago when you really think about it. Next slide, please. So we're going to break it down into sort of a little process. The first read, the second read, and then the brief. So we're walking you through how you are going to brief a case. Next slide, please. So the first read, when you are reading that case for the first time, don't put too much pressure on yourself. You're going to be identifying the parties in the case. Who is this dispute between? What is the court, or which court is deciding the case? And then read the opinion of the case. Look at what happened. What are the facts? What's the story of this case? What is a legal question asked? And what was the resolution? How did things end? So that's if you can at least get that on the first read, you're doing well. Next slide, please. Just keeping an eye on my time here. So identifying the parties in the case. Okay, yes. So when you are trying to identify the parties in the case, one of the first things that you'll do is obviously look at the caption. Take a look at the facts. Try to determine who is involved. What are their names? What are the relationships? Some people are visual learners. Sometimes it helps, especially if it's a little bit complicated. In terms of the parties, you may want to draw it out, little symbols, or it may be very easy to identify um, who the parties are in that case. So that might be fairly easy. And this is something if you are, if you have your laptop open, if you prefer to have a pad of paper open, jot the parties down, get them straight in your head. Maybe you can even, if you've got a legal pad open, maybe you want a little bit more than just the names, kind of like who is, again, this is your story. Who are the characters in the story? So give a little bit of information, identifying information, but kind of their role, whatever you feel like is important, but just sort of get to know the characters of your story. Next slide, please. So in our loving case, I forgot that this does this. In our loving case, the plaintiffs are, and again, for those of you, I think most of you are familiar with this case, but this is the case of marriage equality, allowing people of different racial backgrounds to marry. Believe it or not, before this case, it wasn't necessarily allowed everywhere. So the plaintiffs were Mr. and Mrs. Loving, a married couple, and then the respondent was the state of Virginia. Okay, and then click again, Brian. So the next step, after you've identified the parties, we're going to identify the court deciding the case. And so using the Loving case as an example, the court deciding the case is the Supreme Court of the United States. We know this, so we look to see the reporter referenced in the citation. So you look at the case citation, we see U.S. So we know that stands for this is the court deciding the case is the Supreme Court. Okay, and then click again, Brian. Thank you. And then take a look at what year the case was decided. This is important. Think about, you're doing legal research. So you maybe you have an issue in 2026. What year the case was decided can be important. Maybe nothing's changed with regards to that issue, but maybe it has. Was this a case from last year? Was this a case from the late 60s? And click again, Brian. So we know from our citation, the year that the case was decided was 1967. That is part of the case citation. And then click again. Okay, so we are still in the first read. Now we have key information before us. So then read the opinion of the case, noting what happened, the legal question asked, and the resolution reached. So this may not necessarily be that clear to you initially, but that's what you're looking for. It's like a little scavenger hunt within that brief, and within the case, and this gives you like a plan of action. What am I looking for here? And just try to get to those three, answer those three questions on that first read. Again, doesn't have to be perfect. It can just be, an overview, but just get the gist of what happened. Okay, and click again, Brian. So after this first read, you have sort of a good idea of like, okay, who are the players? What is the issue that the court's trying to decide? What is the time period? When did this take place? Which court is hearing this case? If you're not, most people are familiar with the United States Supreme Court, but say you are, say it's another case, we're not the Loving case, you're not familiar with the court that the opinion is coming out of. Go do a little research on that court. Maybe, what kind of court is it? Just do a geographically, where is it? Federal or state court? Do a little research. It's okay if you look at the citation and you see and you're like, I don't really know. I'm not familiar with this particular court. Do a little research. No, nobody's expecting you to have a good grasp of every single court in the United States. Okay, so the second read, now you're reading to understand the case. The first read is more of your overview. Okay, I've got a good handle on the basics. The second read, now you're reading to understand. Next slide. And so here we have the FIRAC method: facts, issue, rule, analysis, and conclusion. And I think, everybody loves, well, everybody often feels like the first three, maybe even the fifth, are sort of the easy sections, and that the analysis can, at least for me, the analysis was always the trickier part, the more confusing part, the challenging part. However, the facts section could be a challenge in and of itself. If you are like me and you're like every single fact is important, and you really have to fight with yourself to say, wait a minute, I cannot rewrite the facts section of this. I can't rewrite everything. It's a 20-page case. I'm not going to have a 10-page facts section. So I really have to struggle with myself, like, no. What are the important facts? So the facts section could be a little bit challenging as well. So each of their own sections poses their own challenge. But again, in the end, the result is that you've really sort of distilled the case down into these necessary elements that are, again, going to really help you understand the case, understand what that opinion is all about, and then you'll be able to decide, is it relevant to the issue you're researching? Is it relevant to whatever case you've got? Next slide, please. And I think you may have to click again. Yes. Great. So the facts are a great way to start the brief. As we discussed, they're also, they're in that case. So they're easy to spot. So I don't think you're going to have a lot of trouble, seeing where these facts are. Not the issue, but you'll have to use your discretion as to what facts are important. When you start learning how to brief, these are going to be the most noticeable difference among cases. So obviously, a lot of the legal issues, especially if you're researching a specific legal issue, the legal issues may sort of sound the same. The facts can be wildly different, even though they're sort of similar legal issues. And so what you're going to look at when you're beginning to brief the case is, what are the facts in this case before me? What are the facts? Isolate them, and then figure out which are important. Next slide, please. Oh, Brian. Yes. You know what, Brian? I really like that. Brian says, I like to include a brief procedural history in the facts section. When I was in law school, we actually had procedural history. We had to include a procedural history as part of our case brief. So it was actually a designated section. So sometimes then after law school, I struggle, well, where do I put that? So the facts section is a great idea. The procedural understanding where that case has been before it's been to the current court that you're reading the opinion from can be very helpful. So that's great advice. So Mr. Loving, here are the facts here. I don't think let's see, in the interest of time, just keeping an eye, I won't read them all. But these are the facts of the case. So you're only including those facts necessary to clearly explain the analysis to the court. Again, relevant facts. The plaintiffs pled guilty to a violation of a state statute prohibiting interracial marriage. They got married and they weren't supposed to. Plaintiffs sought to have their convictions vacated as unconstitutional under the 14th Amendment. That was unconstitutional. We should have been able to get married. Next slide, please. And now we're looking at the issue. And by the way, you can look back at the facts, the actual facts of the Loving case, um, at a later time. I believe this PowerPoint will be available on the YouTube channel along with the recording, so you can keep this. So what is the issue? This is the legal question that is being asked in the case, and it's always asked, or it's always stated in the form of a question. So you're focusing on the law, not fact. And it's always helpful, just start it with whether, and that gets you, puts you in the position to frame that issue. A case may have more than one. This is where I remember in law school, I would get a little confused. The case may have more than one issue being addressed by the court. Each issue would be listed separately and numbered. Now, remember, it may have, let's say it has three legal issues, but only one of those issues is related to what you're looking at. I mean, you probably could choose, if you're sure of that, you probably could choose to just focus on that one issue in the brief. Okay, and then next slide, please. So there were three issues in the Loving case: whether the Virginia law restricting marriage based on, I believe it's race, violates the 14th Amendment of the Constitution. Second issue is whether the due process and equal protection clauses of the 14th Amendment can be used to invalidate the Virginia laws restricting marriage based on race. So can those clauses invalidate that state law? The third issue is whether the statutory scheme adopted by the state of Virginia to prevent marriages between persons solely on the basis of racial classifications violates equal protection and due process. So these are the issues, and it boils down what the Supreme Court was looking at in this case. Next slide, please. So now we're looking at the rule. Another word used is the holding, and actually we use the holding. I think in law school, in most of my classes, we used holding instead of rule. Same thing though. What did the court hold? But the rule is the answer to the question posed in the issue. So issue is a question, rule is the answer. And it expressly answers the issue question, yes or no, with an additional explanation. Again, it's not going to be this, long-winded explanation. It's going to be some additional explanation, but that will come next in that analysis section. If there's more than one issue, there's going to be more than one rule, and they always correspond. Next slide, please. So as you can see here are our 1, 2, 3. These were our rules. And then, these were our issues. And then in bold, that is the rule. So for example, let's take the second one. Whether the due process and equal protection clauses of the Fourth Amendment can be used to invalidate the Virginia laws restricting marriage based on race. And that's the issue. The court decided, yes, the Virginia laws restricting marriage based on race are violative of the due process and equal protection clauses of the 14th Amendment. Virginia shouldn't have made that law. And then, so as you can see, the rules correspond with each of the issues. Devin, that's a good question. Are they always in bold under the issue in each brief? I usually, if you're doing the FIRAC format, the rules would be like if there were 3, they'd be numbered. But I don't usually include the rule, I don't usually include the issue in the rule section. I would just have 1, yes, the Virginia laws, 2, yes, the Virginia. Do you see what I mean? We included the issues on this slide just to show you how they correspond. But that's a really good question. When you were actually doing the brief, I would just have it's not wrong if you include it, but again, usually, the issues will be right above it, so you wouldn't have to really restate the issue. But yeah, I would definitely, if you have several issues, you want to number the rules so that anyone can see that they correspond. Yes, Jess, right. You would normally have these in separate sections in the brief entirely with corresponding numbers, right? Right. And now this might be one of those things, I don't know, Brian, what you think, but this is also sort of a matter of preference. But I would say it's not wrong to include the issue, but um, again, you're trying to sort of simplify and organize. So it's probably better just to include the rule in the rule section because, again, whoever's looking at it can just scroll up and see the issues. Yeah, it's a style preference for you. Yeah. Yeah. And again, if we're trying to simplify, maybe you just want to have the rules together. And now analyzing what happened in this case. This is our all of our favorite sections. um, and then click again. But again, it can be challenging um, to to draft this section if you're not completely sure about what actually happened in the case. So if you are having trouble with the section, that is probably um, okay. That is probably a little reminder to, hey, why don't you go back and read that case again? Okay, so it addresses the why of the case. Another term is rationale or reasoning. It's the most detailed portion, and it explains the process the court moved through to get to the conclusion. So it kind of outlines their reasoning. Next slide. So, oops. Yeah, so here is and so again, this is going to be good to look back at because you can kind of look at if you actually take this PowerPoint and have the case open, you can kind of compare, okay, what happened here. So this is the analysis section on the right. You're going to look to the reasoning of the court in drawing the final conclusion. Sometimes they're very obvious. They'll say, we reject the state's claim. And you're like, that's what they're literally telling me what I need to put in this section. Sometimes they're not as good about, they're not as direct and you have to figure it out. Include enough information to explain what the court was relying on in making the decision, including facts as needed. So again, you're not restating all the facts, but you may need to state some facts just to sort of explain how the court got to their decision. Next slide, please. And then the conclusion. The plaintiff's convictions were reversed on grounds that the Virginia law violated the equal protection and due process clauses of the 14th Amendment. And again, the court determined that marriage is one of the basic civil rights of man. It is a fundamental right. It's fundamental to our very existence and survival, which is true. Next slide, please. Yes. And the conclusion is the outcome of the FIREC analysis. Thank you, Katrina. What exactly happened? Here's a little comparison of the traditional and see, yeah, actually, I think we did the traditional in law school. FIRAC is kind of like simplifies it. It's more practical. Next slide, please. Here are just an overview of when you may use it. Remember that these are neither is submitted to the court unless I think Brian mentioned for summary judgment. In that case, maybe they are, or I don't know if Brian, you meant that you were using them in preparation to do motion for summary judgment. But again, most of the most of this information are sort of most of the information in the brief is sort of used in-house. So that's why it could be like the actual style of the brief is going to be more flexible. If you're briefing the case for yourself, it's going to be based on your own preferences. Next slide, please. And then the traditional are include a lot more information. court briefs versus a case brief. No, I think we're right at the end. Um, Here's a comparison. Next slide, Brian. I'm going to end on one thing too. I want to mention one more thing at the very end. Um, so here's another example. So I did want to mention, I brought up at the very beginning AI. So again, I always preface any explanation or any discussion of AI with our Purdue Global AI policy. It's readily available. You all have access to Google's Notebook LM. So I challenge you to see how well to experiment with it a little bit. Obviously, you're going to want to do these case briefs on your own, right? But Notebook LM is a great tool. And with Notebook LM, you actually upload your own sources to Notebook LM. I challenge you to work with Notebook LM and see if you can find a way to say you upload the case downloaded from Westlaw, put it into Notebook LM, and see if you can get Notebook LM to brief the case for you. Again, it's a closed tool, unlike ChatGPT or Google Gemini, and you all have a student account. So anyway, thank you all. And the one thing that you can do with that is then check your case brief and then compare it with what Notebook LM does and see if it picks up things you didn't or vice versa. Thank you all.